Bill Henshall here again, Constitutional Crisis Channel, and this will be a little video on trying to keep yourself out of jail in South Carolina based on my experiences. And I'll say up front that, California is certainly not perfect, anywhere near that according to the Constitution, but here you can deal with things much more effectively than you can there, especially if you have no right to be represented by counsel. And I'm still taking that position. As you'll see in South Carolina, I'm going to make a powerful exception, and it may be good across the country. But in plain point of fact, I found out later, on August the 2nd, the last day I was there, my liaison counsel told me I could have gone home on April the 7th if I would have been represented by counsel. Now, geez, if I had known that, and what I didn't know throughout my stay there was, and I'm a hell of a legal researcher, anybody that knows me is going to tell you, I know what I'm doing. Well, I couldn't find any protocols in writing on law and motion practice in South Carolina as we can do in California. It's comparatively simple. You set up your own motions, you have to give them 5 weeks notice, except under emergency circumstances. You can move to shorten time. There was nothing there about that, which was bad enough. Even worse, in one way, is that I found out that the solicitor, which is what they call him back there, we have the DA here, but the solicitor, who's an executive officer, has a lot of controlling authority over the court dockets in South Carolina. Now, that can't be. And this is where we're going to get them. I'm going to get them in my case, and if we have these things going on across the country, you're going to get them too, because that's separation of powers. Those courts, in theory at least, are supposed to be judicial, not executive. There's no room for the executive to come in there and tell the court what it's going to hear and when it's going to hear it. As in my case, I sat there for 7 months, 5 months in South Carolina. I never had a hearing, and I put in for several, including federal writs of habeas corpus, that they can't control. Never had one. Never was going to have one. Because if the DA or the solicitor can control the hearings, in the last motion I put in, I said, when's the hearing going to be? 2018? Once I figured this out. Well, what I also found was that the South Carolina Court of Appeals had ruled the statute unconstitutional, which gives them this authority, and yet liaison counsel, who also knew this, didn't seem to be bothered by it. So this still goes on. So these are things that you don't have any way of knowing, and I didn't have any way of knowing, and I know what the hell I'm doing. Even worse, in South Carolina, there is no access, to the court website. So you don't know, you can't schedule a hearing from there, which maybe you should be able to do. But the whole thing is a mess. So you don't want to get in there, and then you go to a bond court hearing, quote unquote. Maybe you get bond or bail set, maybe you don't. I did in my particular case. It's a funny story, I'll tell you more about in another video. But we had people in there that had been severely overcharged pursuant to the crimes they may or may not have committed, especially criminal domestic violence. And when that happened, the bond was much higher than it should have been, like $50,000 or $60,000, and they can't post it, and they've got to stay in jail and away from their families who need them, and all because they were overcharged and maybe didn't even do a third-degree domestic violence, let alone a first-degree one. So you're sitting there in jail with no access and no way to present your case and nothing. And you're tied to the public pretender who might show up once a month if you're lucky. The whole situation is ludicrous, and it has to change. And as a result of my case, I think a lot of changes are going to get made in the way they do business there. That's still perspective, to be sure. But they know me well enough to know now that if I have to, I will go to the Supreme Court of the United States, and I've already got a handwritten writ sitting there. And I'm going to tell them, you want me to do that and force the court to do it on the record, you're going to get bankrupted by suits for false arrest and imprisonment. A subject matter you're going to hear much more about on future videos. This is part of the power we have against them, is to do just this. Thank you.